Hirschfeld v. Johnston names over a dozen state and county child support officials across Colorado and South Dakota. The complaint details the human cost of the alleged constitutional violations. The state executed the seizure of over $116,000 in assets and suspended the plaintiff's driver's license. Deprived of his sole source of income as a rideshare driver, the plaintiff documented 527 consecutive days of homelessness. The entire decade of enforcement actions relies on a central paradox. These property seizures and administrative sanctions were built on a foundational state court order that the records show never existed. This case examines an administrative system operating on automated triggers. While the agencies followed internal policy manuals, the plaintiff alleges they blinded themselves to the requirements of the U.S. Constitution. We are going to deconstruct the procedural blueprint of this lawsuit. We will examine how the plaintiff engineered a 6-count federal civil rights complaint by relying on the state's own internal records. The objective is to demonstrate how documentary evidence can be used to bypass administrative buck passing. The plaintiff uses the state's own paper trail to challenge qualified immunity and link individual actions to municipal policy. In this litigation, raw outrage is replaced by precise forensic math. The base layer of this legal blueprint requires exposing the missing judicial predicate. In the litigation, this is referred to as the nuclear fact. This is the official Icon Minute Order from the Larimer County Court, dated June 10, 2015. The court explicitly states it was, quote, unable to enter support orders as we are missing SSN for children. Colorado law, specifically CRS Section 2613-106, establishes the provision of Social Security numbers as a mandatory statutory prerequisite. Without them, the plaintiff argues the court lacked the jurisdiction to enter a valid support order. Under this theory, the absence of the statutory prerequisite renders any subsequent order void ab initio, invalid from the outset. This means a decade of agency enforcement actions was conducted without a lawful judicial mandate. On top of this missing foundation, the state faces allegations of mathematical fraud through the intentional misapplication of child support calculation formulas. This diagram shows the legal distinction under Colorado law. Worksheet B is required for shared physical care to offset costs between both households. Worksheet A is designed for sole physical care, where one parent holds the children 100% of the time. Despite written acknowledgments from agency personnel that the parenting plan established shared custody, the state applied Worksheet A. The plaintiff argues this manufactured between $50,000 and $70,000 in fictitious debt. By building a financial extraction machine on a legal phantom, the plaintiff alleges the state violated the 14th Amendment's procedural due process clause with every dollar seized. The first load-bearing pillar of the federal lawsuit dismantles the jurisdictional evasion between Colorado and South Dakota. To avoid accountability, Colorado officials engaged in administrative buck passing. They formally deferred legal authority to South Dakota, telling the plaintiff in writing, quote, I'm only here to collect money. South Dakota officials internally contradicted that deference. In their own written communications, South Dakota stated they possessed, quote, no jurisdiction over the case. Under the Uniform Interstate Family Support Act, or UTSA, Colorado retained continuing exclusive jurisdiction. Because the plaintiff maintained his Colorado residency, South Dakota lacked the authority to independently enforce the debt. This email from South Dakota Supervisor Larry Boyd, dated June 4, 2025, details their actual enforcement strategy. He admits they gather employment data and, quote, we share that with Colorado so they can enforce. The plaintiff uses this admission to show South Dakota officials bypassed formal UIFSA registration. Instead of following the federal framework, they maintained an informal interstate enforcement arrangement. This map shows how the plaintiff weaponized Boyd's email to satisfy the Calder effects test. By selecting a Colorado employer to trigger wage garnishments, South Dakota purposefully directed the harm into Colorado, establishing personal jurisdiction in a Colorado federal court. The agency's attempt to use jurisdictional chaos as a shield provided the documentary evidence needed to lock out-of-state defendants into the litigation. The second pillar of the lawsuit establishes willful violations of the Fair Credit Reporting Act by South Dakota officials. Re-aging occurs when a furnisher reports an old delinquency to the credit bureaus as a brand new account. This unlawfully restarts the FCRA's 7-year adverse reporting penalty clock. This timeline tracks the forensic credit data from Exhibit 15. It documents what the complaint terms a triple reporting violation. The original account was opened in May 2017. 4 years later, the records show the first illegal re-aging event. On February 10, 2021, the agency reported the pre-existing debt to TransUnion as a brand new account. The second re-aging event occurred 6 months later, on September 9, 2021. The state again reported the same debt to TransUnion as a new account. A critical legal trigger occurred between these two events. In August 2021, the plaintiff filed a formal consumer dispute, which mandated a statutory duty for the state to conduct a reasonable investigation into the debt's accuracy. The complaint alleges the state ignored this duty, falsely certifying the phantom debt as accurate and verified, and suppressing the plaintiff's FICO score to a 461. These credit alerts are used to argue that the state's actions were not passive computer errors, but a calculated mechanism designed to inflict willful financial ruin. The final capstone of the legal blueprint involves piercing qualified immunity and establishing Monell municipal liability against the county. To hold the county liable, the plaintiff must prove the violation was an official custom or was ratified by a final policymaker. This email from October 10, 2025, is used to prove actual notice. The plaintiff explicitly informed agency leadership that, quote, there was never a child support order entered, and warned that every dime was collected illegally. This email establishes deliberate indifference. It provides evidence that top supervisors had written knowledge that the foundational order was missing, yet chose to continue the enforcement actions. The final evidence of municipal liability is found in Exhibit 14, the February 5, 2026 ratification letter, authored by Larimer County Human Services Director Heather O'Hare. Confronted with the 2015 court record, O'Hare officially defended the agency's actions. She dismissed the fatal jurisdictional defect, labeling the court's own minute order, quote, simply the notation of the court clerk regarding a purely administrative function. By officially defending the administrative process in writing, the director provided the specific evidence required by Monell, linking the final policymaker directly to the custom being challenged in federal court. The litigation tests the point where state administrative discretion meets the due process requirements of the 14th Amendment. Under the standard established in Turner v. Rogers, a state cannot impose severe coercive sanctions, such as a license suspension, without first conducting a mandatory ability to pay hearing. This calendar tracks what the plaintiff alleges is immediate retaliation. On March 17, 2026, U.S. Marshals served the federal summonses. On March 18th, exactly 24 hours later, the state generated a new driver's license suspension notice. Generating a license suspension notice immediately after being served is used as proof of First Amendment retaliation. The state bypassed the mandated hearing process to target the plaintiff's income. Because the plaintiff relied on rideshare driving for his survival, this imminent threat established the irreparable harm necessary to demand emergency intervention from the federal court. By mapping every seizure and sanction to the state's own missing records, the Hirschfeld complaint provides a blueprint for holding a complex administrative system to its constitutional requirements.